CBS News legal analyst Jack Ford is with us. Jack, good morning. So as you look at this stuff that's coming out, one of the things obviously that stands out for a lot of people is this lead investigator who told the FBI that he didn't think Zimmerman attacked Trayvon Martin because of his race. How important is that statement here?
One of the things you have to keep in mind, Erica, is just because something is contained in a police report or a police interview doesn't make it admissible. So you can have thousands of pages of documents with all sorts of opinions. The reality is very little of it will actually get inside of a courtroom. So, for instance, somebody having an opinion saying he's a good guy, he's a bad guy, he's guilty, he's not guilty, he's a racist, he's not a racist. Generally speaking, those witnesses don't get to say that inside of a courtroom, because the idea is jurors are told you're going to decide this case on the facts of the case alone, not what opinions people might have. Now, there's some exceptions to that. Certainly experts can come in and give opinions, but a witness can't come into the stand and into the courtroom, take the stand and say, yeah, you know what, guys, I think he's guilty, or you know what, guys, I think he's a racist. Now, the fact that they're saying that might color some of the testimony, and a good defense attorney might be able to sort of draw out something similar to that in the case. But people have to realize just because you're hearing these opinions doesn't mean that the jurors will hear those opinions.
I mean, I guess the same thing goes for the same investigators talking about that he had this sort of little hero complex, which I guess is something that the prosecutors could jump all over.
You know, you would like, if you're a prosecutor, you'd like to get that in there,
right,
because that would explain, if you're the prosecutor, what you say is aggressive action by him. But again, the bottom line is you're not going to allow, a judge is not going to allow somebody who's not qualified, who's not a psychiatrist, and even if he was, to come in and say to the jurors, let me tell you folks why I think he did this. He probably had a hero complex type of thing. But what is interesting about the same investigator is he said, but I could see where he would feel that this was suspicious because Trayvon Martin was wearing a hooded sweatshirt and wandering around an area where there had been burglaries.
Right.
Well, a good defense attorney might be able to get some of that into the case in some fashion, and that is huge for the defense, because that's exactly what George Zimmerman is saying. I had a reasonable belief that I was in fear of my life, and that's what they have to prove. Now, it might turn out that he didn't have a reasonable belief, but if there were circumstances that suggested that, that's good for the defense.
As you point out, a lot of what we've been hearing, because we keep getting these sort of information dumps, could not ultimately end up in court.
They make great headlines.
They make great headlines. They give us a lot to talk about. What then is the reasoning? What is the benefit to putting all of this information out there ahead of time?
The reality is it's the law in Florida. In Florida is a sunshine law state, and it says all of this stuff gets out there. Other states, prosecution gives it to the defense gives it to the prosecution. Sometimes the judge will say, I don't want it getting out there, I'm going to put a lid on it. It happens to be a state where the rules say everything gets out there. It actually can create problems for both sides, because potential jurors might be hearing stuff that is not going to get into the case. So now the lawyers have to work through that in the jury selection process.
You read my mind on the next question about the jurors. Jack, thank you.
Thanks, Jack.